Hello, hello, everybody. Hello, welcome, welcome in. Good to see you. Hello, good evening, good evening. Hello, welcome, welcome. Yes, we've got quite the filing. Why doesn't that look right? Did I spell that right? Help me out, Frank. Did I spell filing right? Hello, hello, good evening. Hi, everybody. Hi, Kate. Good to see you. Hi, Jay. Welcome, welcome. Welcome. Yes, it's quite a bit. And seriously, Frank, did I spell it correctly? Okay, I did. Okay, thanks, everybody. Oh my gosh. I tell you what, it has been a day. It has been a day, my friends. Okay, thank you. Oh my gosh, I tell you what, it's spell check. Yes, definitely reading it tonight. Definitely reading. Oh my gosh, everyone. We've been, waiting for this. Now, Mr. Trump's response to the redactions was due, and I was wondering if Judge Chutkan was going to go ahead and put out the filing then after the redactions had been put into place. So, yay! Happy to see that. Oh, my day's just been kind of, one of those days where you're like, okay, what just happened? My machine programming to be with you. Oh my gosh, Frank. Oh, you're so sweet. Thanks so much. Thanks. Well, welcome in, everyone. Welcome. So as most of you have heard, we have our filing. It has been redacted. This is just the filing, not the appendix. But we've got Jack Smith's motion here for immunity determinations. Now, for those of you who may not know or haven't been around, we have a superseding indictment that was filed in the DC case against Mr. Trump. And we had the original indictment go all the way up to the Supreme Court. They came back with this immunity decision where Roberts has set out this kind of immunity thing. We don't know exactly how it's supposed to work, but official acts of presidents and former presidents are supposed to be immune. But what official acts are, well, we don't have a definition of that. That has not been defined. So we're kind of going to need to figure that out as we go, which will take a lot of time for sure. But we're stepping towards that first process. So Jack has filed this brief. It is again redacted. It's huge. It's 165 pages, everyone. So we will need to do multiple lives, of course, on it. It's broken down into a few different pieces here. And then, of course, Mr. Trump will have a chance to respond. And then there is a sir reply. Just a regular reply that could occur after this. So lots of things kind of going on here in DC at the moment. Yes, I would say the redacted portions, everyone, you could probably figure it out. Now, the redactions are because we do have a protective order in the DC case regarding any witnesses that have been named here. So all witness names have been redacted in order to protect them, along with any court staff or various other people listed in the protective order. So that's why we have redactions. Any kind of confidential or classified information, that was in the Florida case. We're not really dealing with that in this case. With the redactions here, we're dealing with the names of the witnesses and so on. So that's primarily what we're dealing with. Yes, this is online. You can pull it up. For those interested, this is the case number here. If you put that case number into your search engine, you can pull up document 252, which is this filing here, and then pull it up yourself if you are interested. So again, it will take me a few lives to get through this information. I do want to read the facts. Usually I'm okay skipping around, but with how he set the facts out here, I think it's okay to just kind of read it straight through. I think it'll be much more interesting for everyone, and we can kind of catch some pieces here and there that we can kind of chat about. So also, again, as a friendly reminder, this is all based off of the superseding indictment, everyone. We had our original indictment that was the one that went up to the Supreme Court and then back down again. And then Jack on August 27th filed the superseding indictment. He made a few changes in it. And those changes were made because of this immunity case situation that came down from the Supreme Court. So our superseding indictment's a little bit different than our original indictment. He is referring to the superseding indictment in his motion. So as we go through, if you see any citations to the indictment, he is referring to the superseding indictment. There were several questions regarding Vice President Pence and Mr. Trump being able to speak with various other people. And what Jack's done here he's put in a rebuttal into this. Yes, this will take several pieces. So how it's broken down, I'll just give you a quick overview before I dive in. How he has broken it down, he's divided it into just 3 pieces. First, he has set out a facts proffer. So factual proffer just means these are the facts he's relying on in order to set out his legal argument. Now, of course, as we know, his legal argument's going to be everything that's in that superseding indictment is not immune. That's why it's in the indictment. So he sets out a huge set of facts, which is what we will get started with. We're going to go through overall what the facts are. There are some new facts in here. I'm not sure anything is just going to be a hugely interesting. I find all of it interesting, but he does go through each individual state, and there's quite a bit more facts in here than there were in the superseding indictment. So he has added a lot of information. So we're not dealing with the same set of facts as in the superseding indictment. So he set that out. He's also gone into, again, the electors scheme, which is a huge part of the superseding indictment. Then he spends quite a bit of time talking about Mike Pence, right? Because the Supreme Court had kind of hinted that his conversations with the vice president should be immune. They shouldn't be something that could be included. And so Jack's gone in here and said, well, let me tell you why we think these conversations are okay to be included. So he sets that out as well. Then he does go into specific conduct of Mr. Trump on January 6th. So that's the first piece. That's just the facts. Next up, we've got the legal framework. So this is where he starts to break down that immunity brief, the immunity decision that was given by the U.S. Supreme Court, where John Roberts decided to go ahead and create this new immunity defense. And he sets out what he believes, how he believes that case reads, and puts that into just a few pages. Then takes that and comes in and says, look, we've given you the facts. This is what the case is that you just decided, Supreme Court, and we're going to tell you none of the allegations or the evidence is protected by presidential immunity, and we're going to tell you why. So that is the remainder of the brief that he has filed. So those are the 3 parts to the filing that he has here. The proffered facts, including a lot of facts that were not in the original indictment or the superseding indictment, going through how that U.S. Supreme Court decision on immunity is, and then applying and setting out the argument that these facts, these charges, are not covered by presidential immunity. All right, so that's how this is broken down. I will, again, start out just reading here verbatim because I think it's so important, their introduction piece, and then we'll start going through these facts. Now, I will be kind of glancing over and doing a Q&A as we go through this, but as we go through these facts, I will point out anything that is new from that was not in the superseding indictment. And that's just because I've read the indictment so many times, I'll be able to figure out, hopefully, what has been added to it. All right, everyone. So let's go ahead and get started. Here is my sticky notes. We have the DC filing. This is the immunity filing, and it was filed today. So here we go. Let's get started. Government's motion for immunity determinations. And I will go ahead and start with some tea. Have I had a good day? It's been an okay day. It's been kind of an odd day. One of those like, what? But we're getting there. We'll get there. All right, so slurping my tea so all of my relatives can just be scowling at me. Government's motion for immunity determinations. The defendant asserts that he is immune from prosecution for his criminal scheme to overturn the 2020 presidential election because he claims it entailed official conduct. Not so. Although the defendant was the incumbent president during the charged conspiracies, his scheme was fundamentally a private one. working with a team of private co-conspirators, the defendant acted as a candidate. This is the key, everybody. When he pursued multiple criminal means to disrupt, through fraud and deceit, the government function by which votes are collected and counted, a function in which the defendant as president had no official role. So this is going to be the primary argument here. That in the Constitution, the president has no official role when it comes to how to go about counting votes. All right, so grab onto that as we go through the rest of all of this. In Trump v. U.S., so that's the immunity decision, the Supreme Court held presidents are immune from prosecution for certain official conduct, including the defendant's use of the Justice Department in furtherance of his scheme, as was alleged in the original indictment, and remanded to this court to determine whether the remaining allegations against the defendant are immunized. The answer to that question is no. This motion provides a comprehensive account of the defendant's private criminal conduct, sets forth the legal framework created by Trump, so that's the immunity decision, anytime that's in italics, everyone, for resolving immunity claims, applies the framework to establish that none of the defendant's charged conduct is immunized because it either was unofficial or any presumptive immunity is rebutted. So we're going to talk about rebutting that presumption quite a bit. That was the second piece that Roberts put into this immunity defense, saying that there is this presumptive immunity in certain situations, but that the government can come in and rebut that immunity. And so he does. He comes in and says, even if you're going to say there is a presumption here, we are rebutting it. And request the relief the government seeks, which is at bottom this, that the court determines the defendant must stand trial for his private crimes as would any other citizen. So that's our first start. Yes, we do go pretty light on politics when we're in here, everyone. I do try to kind of keep it focused on the law as best as we can so that it's not too overwhelmingly stressful for people. This motion provides the framework for conducting the necessarily fact-bound immunity analysis required by the Supreme Court's remand order. It proceeds in 4 parts. Section 1 provides a detailed statement of the case that the government intends to prove at trial. This includes the conduct alleged in the superseding indictment, as well as other categories of evidence that the government intends to present in its case in chief. This detailed statement reflects the Supreme Court's ruling that presidential immunity contains an evidentiary component, which should be addressed at the outset of a proceeding. So this is kind of a unique where the Supreme Court is saying that Judge Chutkan needs to make an evidentiary determination. All right, so that's why we're going to need to have some proffered facts in here. Section 2 sets forth the legal principles governing claims of presidential immunity. It explains that for each category of conduct the Supreme Court has not yet addressed, this court should first determine whether it was official or unofficial by analyzing the relevant content, form, and context to determine whether the defendant was acting in his official capacity or instead in his capacity as a candidate for re-election. And we're citing the Blessing Game case, which is an ongoing civil case. And the only case we have kind of talking about this distinction between President Trump and candidate Trump. All right, so there's a distinction between those two functions. Where the defendant was acting as office seeker, not office holder, no immunity attaches. And again, this is the pivotal piece out of the Blessing Game case, which is an ongoing civil case in D.C. For any conduct deemed official, the court should next determine whether the presumption of immunity is rebutted. So this is the second piece, all right? So is that presumption rebutted, which requires the government to show that applying a criminal prohibition to that act would pose no dangers of intrusion on the authority and functions of the executive branch. So this is the test for presumption, for rebutting our presumption. Okay, everyone? Section 3, which is also quoting Nixon v. Fitzgerald, which many of you know is my least favorite case of all time now. Section 3 then applies those legal principles to the defendant's conduct and establishes that nothing the government intends to present to the jury is protected by presidential immunity. Although the defendant discusses with the vice president about their official responsibilities, qualify as official, see the Trump case, the government rebuts the presumption here. Rebuts the presumption of, immunity, and all of the defendant's remaining conduct was unofficial. As content, form, and context show, the defendant was acting in his capacity as a candidate for re-election, not in his capacity as president. In the alternative, if any of this conduct were deemed official, and we always argue in the negative whenever we are making our arguments here, the government could rebut the presumption of immunity. Finally, Section 4 explains the relief sought by the government and specifies the finding the court should make in a single order, namely that the defendant's conduct set forth in Section 1 is not immunized, and that is, as a result, the defendant must stand trial on the superseding indictment, and the government's not prohibited at trial from using evidence of the conduct described in Section 1. All right. Oh, you're very welcome. You're very welcome. It is pretty easy to understand. I would agree with that. He does a pretty good job. He and his team. I mean, as we know, it takes a village here, so it's more than just one person. So here's the factual proffer, everyone, and I will again take you through. I don't want to skip through the facts because we do have some new facts that have been added, some new to the public facts. So as I take us through that, here we go. Factual proffer. When the defendant lost the 2020 presidential election, he resorted to crimes to try to stay in office. With private co-conspirators, the defendant launched a series of increasingly desperate plans to overturn the legitimate election results in 7 states that he had lost. Here, so we've got Arizona, Georgia, Michigan, Nevada, New Mexico, Pennsylvania, and Wisconsin, the targeted states. His efforts included lying to state officials in order to induce them to ignore true vote counts, manufacturing fraudulent electoral votes in the targeted states, attempting to enlist Vice President Michael Pence in his role as President of the Senate to obstruct Congress's certification of the election by using the defendant's fraudulent electoral votes. And when all else had failed, on January 6 of 2021, directing an angry crowd of supporters to the United States Capitol to obstruct the congressional certification. The through line of these efforts was deceit. The defendants and co-conspirators knowingly false claims of election fraud. They used these lies in furtherance of 3 conspiracies. Number 1, so this is, if we were in Georgia, we would call this the beginning of our RICO here. Number 1, the conspiracy to interfere with the federal government function by which the nation collects and counts election results, which is set forth in the Constitution and Electoral Count Act. 2, a conspiracy to obstruct the official proceeding in which Congress certifies the legitimate results of the presidential election. And 3, a conspiracy against the rights of millions of Americans to vote and have their votes counted, which in my opinion is the most significant piece here. At its core, the defendant's scheme was a private criminal effort. So again, this key term is private, everyone. In his capacity as a candidate, the defendant used deceit to target every stage of the electoral process, which through the Constitution, ECA, and state laws includes the state's notifications to the federal government of the selection of their representative electors based on the popular vote in the state, the meeting of those electors to cast their votes consistent with the popular vote, and Congress's counting of the electoral votes at a certification proceeding. As set forth in detail below, the defendant worked with private co-conspirators, including private attorneys, this one, and this one, and private political operatives, which again, I think we all can probably figure out who these people are. CC6P1, the defendant also relied heavily on private agents such as his campaign employees and volunteers, like campaign manager P2, deputy campaign manager P3, senior campaign advisor P4, and campaign operative P3. In this section, the government sets forth detailed facts supporting the charges against the defendant. So we have footnote 1. Section 1 represents the government's efforts to provide the court and defendant with all of the categories of evidence that it may offer in its case in chief at trial. It does not include citations to every potential exhibit, nor does it account for any additional evidence that may be developed before trial. Before addressing the next section, why none of this conduct is subject to immunity under the Supreme Court's decision in the Trump case, the conduct set forth below includes the defendant's formation of the conspiracies leading up to and immediately following the 2020 presidential election. Certain information regarding his knowledge that there had not been outcome determinative fraud in the election, as he persistently claimed, and his increasingly desperate efforts to use knowingly false claims of election fraud to disrupt the electoral process. So this piece here, his knowledge, the intent element is going to play a huge role throughout this entire trial, everyone. So that's why they're going to say, they're trying to show what he knew and what he didn't know. The government does not consider any of the following conduct to be subject to immunity for the reasons set forth in Section 3. So now we'll go ahead and step into the formation of the conspiracies here. Although his multiple conspiracies began after Election Day in 2020, the defendant laid the groundwork for his crimes well before then. Leading into the election, the defendant's private and campaign advisors, including P6, then a private citizen, and P2, the defendant's campaign manager, informed him it would be a close contest and that it was unlikely to be finalized on Election Day, in part because of the time needed to process large numbers of mail-in ballots prompted by the COVID-19 pandemic. And then we have footnote 2 here, which is redacted. All right, so I'm assuming those are going to be page numbers out of the grand jury testimony. That's my guess. They also told the defendant that the initial returns on election night might be misleading. That is, that he might take an early lead in the vote count that would diminish as mail-in ballots were counted, because his own supporters favored in-person voting while supporters of his opponent, Joseph R. Biden, favored mail-in ballots. Thank you. Oh, you're welcome. Absolutely, my pleasure. Again, we've got a redacted footnote here. Privately, the defendant told advisors, including P6 campaign personnel, a White House staffer and campaign volunteer, and P8, the vice president's chief of staff, that in a scenario he would simply declare victory before all of the ballots were counted and any winner was projected. And then we're redacted at footnote 4. Publicly, the defendant began to plant seeds for that false declaration. Don't forget to hydrate. I'll remember, in the months leading up to the election, he refused to say whether he would accept the election results, insisted he could lose the election only because of fraud, falsely claimed that mail-in ballots were inherently fraudulent, and asserted that only votes counted by Election Day were valid. For instance, in an interview on July 19th of 2020, when asked repeatedly if he would accept the results of the election, the defendant said he would have to see, and it depends. And this is footnote 5. So our citations are down here, everyone. On July 30th, despite having voted by mail himself earlier that year, the defendant suggested that widespread mail-in voting provided a cause for delaying the election, tweeting, quote, "With the universal mail-in voting, not absentee voting, which is good, 2020 will be the most inaccurate and fraudulent election in history. It will be a great embarrassment to the USA. Delay the election until people can properly, securely, and safely vote," end quote. In an interview on August 2nd, the defendant claimed without any basis that, quote, "There is no way you can go through a mail-in vote without massive cheating," end quote. At a campaign event in Wisconsin, August 17th, the defendant told his supporters, quote, "The only way we're going to lose this election is if the election's rigged. Remember that. It's the only way we're going to lose this election. So we have to be very careful," end quote. In his acceptance speech at the Republican National Convention on August 24th, the defendant said that, quote, "The only way they can take this election away from us is if this is a rigged election," end quote. On October 27th, during remarks regarding his campaign, the defendant said, quote, "It would be a very, very proper and very nice if a winner were declared on November 3rd, instead of counting ballots for 2 weeks, which is totally inappropriate. And I don't believe that that's by our laws. I don't believe that. So we'll see what happens," end quote. The defendant said this despite, or perhaps because, his private advisors had informed him that it was unlikely the winner of the election would be declared on November 3rd. Oh my goodness. All right. So by October 2020, P1, a private political advisor who had worked for the defendant's 2016 presidential campaign, began to assist with the defendant's re-election effort. 3 days before Election Day, P1 described the defendant's plan to a private gathering of supporters, quote, "And what Trump's going to do is just declare victory, right? He's going to declare victory. That doesn't mean he's the winner. He's just going to say he's the winner," end quote. Oh my gosh. Footnote 11 is redacted. After explaining that Biden supporters favored voting by mail, P1 stated further, quote, "And so they're going to have a natural disadvantage, and Trump's going to take advantage of it. That's our strategy. He's going to declare himself a winner," end quote. Immediately following Election Day on November 3rd, the defendant did exactly that. As his private and campaign advisors had predicted to him, in certain states, the defendant took an early lead on Election Day that began to erode. At approximately 11:20 p.m., Fox News projected that Biden would prevail in the state of Arizona. And according to campaign advisor P4, he and the defendant were shocked and angry at this development. As Election Day turned to November 4th, the contest was too close to project a winner. And in discussions about what the defendant should say publicly regarding the election, senior advisors suggested that the defendant should show restraint while counting continued. Again, all of our footnotes here are redacted, so that's why I'm not reading them. Two private advisors, however, advocated a different course. CC1, CC6 suggested that defendant just declare victory. And at about 2:20 a.m., the defendant gave televised remarks to a crowd of his campaign supporters in which he falsely claimed, without evidence or specificity, that there had been fraud in the election and that he had won. Quote, "This is a fraud on the American people. This is an embarrassment to our country. We were getting ready to win this election. Frankly, we did win this election. We did win this election," end quote. In the immediate post-election period, while the defendant claimed fraud without proof, his private operatives sought to create chaos rather than seek clarity at polling places where states were continuing to tabulate votes. For example, on November 4th, P5, a campaign employee agent and co-conspirator of the defendant, tried to sow confusion when the ongoing vote count at the TCF Center in Detroit, Michigan looked unfavorable for the defendant. Then when a colleague at the TCF Center told P5, quote, "I think a batch of votes heavily in Biden's favor is right," end quote, P5 responded, quote, "Find a reason it isn't," end quote. Quote, "Give me options to file litigation," end quote. And quote, "Even if it's something, even if it's BS. This, everyone, just so you know, is not in the superseding indictment, these quotes here. When the colleagues suggested that there was about to be unrest reminiscent of the Brooks Brothers riot, a violent effort to stop the vote count in Florida after the 2000 presidential election, P5 responded, quote, "Make them riot and do it." Oh my gosh, this is new information here, everyone. So this is new. The defendant's campaign operatives and supporters used similar tactics at other tabulation centers, including in Philadelphia, Pennsylvania. And the defendant sometimes used the resulting confrontations to falsely claim, yes, quite so, oh my goodness, that his election observers were being denied proper access, thus serving as a predicate to the defendant's claim that fraud must have occurred in the observer's absence. Contrary to the defendant's public claims of victory immediately following Election Day, his advisors informed him that he would likely lose. On November 7th, in a private campaign meeting that included P2, P3, P4, and White House staffer P9, who came to serve as a conduit for information from the campaign to the defendant, campaign staff told the defendant he had only a slim chance of prevailing in the election, and that any potential success was contingent on the defendant winning all ongoing vote counts or litigation in Arizona, Georgia, and Washington. Within a week of that assessment, on November 13th, the defendant's campaign conceded its litigation in Arizona, meaning that based on his campaign advisor's previous assessment, the defendant had lost the election. So again, this is showing that he knew he had lost. according to the facts proffered here. That same day, in an implicit acknowledgement that he had no lawful way to prevail, the defendant sidelined the existing campaign staff responsible for mounting his legal election challenges. From P2 to P3 and others who were telling the defendant the truth that he did not want to hear, that he had lost, the defendant turned to CC1, a private attorney who was willing to falsely claim victory and spread knowingly false claims of election fraud. My guess would be this would be Rudy Giuliani here. That's going to be Giuliani because he's a private attorney. Yes, thank you, moderators. I appreciate all of your hard work. Please be respectful, everybody. I'm just reading a document, all right? As the defendant placed alternating phone calls to P3 and CC1 throughout November 13, P1 informed CC6, another private campaign advisor, of the change, writing, quote, "Close, hold, don't tell anyone Trump just fired P3 and put CC1 in charge," and quote, "You are to report to CC1. When CC6 asked if P2 was gone too, P1 replied that they all report to CC1 and that P1 had made a recommendation directly that if CC1 was not in charge, this thing was over. Trump is in to the end," end quote. The next day, consistent with P1 description, the defendant announced his staff change by tweet writing, quote, "I look forward to CC1 spearheading the legal effort to defend our right and free and fair elections." CC1, P10, P11, CC3, P12, a truly great team added to our other wonderful lawyers and representatives. Oh my gosh. All right, here's B. The defendant knew his claims of outcome determinative fraud were false. So again, this new element is the key here. Following Election Day and throughout the charged conspiracies, the defendant, his co-conspirators, and their agents spread lies that there had been outcome determinative fraud in the election and that he had actually won. These lies included dozens of specific claims that had not been substantial fraud in certain states, such as that large numbers of unalived, non-resident, non-citizen, or otherwise ineligible voters had cast ballots, or that voting machines had changed votes for the defendant to votes for Biden. And the defendant and co-conspirators continued to make these unsupported, objectively unreasonable, and ever-changing claims, even after they had been publicly disproven or after advisors had directly informed the defendant that they were untrue. The evidence demonstrates the defendant knew his fraud claims were false because he continued to make those claims even after his close advisors, acting not in an official capacity but in a private or campaign-related capacity, told him they were not true. These advisors included P9, the White House staffer and campaign conduit, and Pence, the defendant's running mate. P9 relationship with the defendant began before P9 worked for him in the White House. P9 had known P13, the defendant's son-in-law, since P13 was a child, and through P13 met P14 and then the defendant. P9 was one of several attorneys who represented the defendant in his first impeachment trial in the Senate in 2019 and 2020, including presenting argument on the Senate floor on January 27th of 2020. P9 began working in the White House as an assistant to the president in August of 2020. Now again, I'm not reading footnotes because they're redacted out, everyone. In October of 2020, P9 became interested in learning more about the defendant's campaign, and in early November of 2020, after he began interfacing with campaign staff, P9 consulted with the White House counsel's office to ensure he complied with any applicable laws regarding campaign activity. Thereafter, and throughout the post-election period, P9 became a conduit of information from the campaign to the defendant, and over the course of the conspiracies, P9 told the defendant the unvarnished truth about his campaign legal team and the claims of fraud that they and the defendant were making. Examples of these instances include, by the way, all of this is new information, not in the superseding indictment. P9 repeatedly gave the defendant an honest assessment that CC1 could not mount successful legal challenges to the election. For instance, when the defendant told P9 that he was going to put CC1 in charge of the campaign's legal efforts, but pay him only if he succeeded, What? P9 told the defendant he would never have to pay CC1 anything. In response, the defendant laughed and said, quote, "We'll see," end quote. Thereafter, in the Oval Office meetings with the defendant, CC1 and others in which CC1 made speculative claims, P9 told CC1 in front of the defendant that CC1 would be unable to prove his allegations in the courtroom. In a separate private conversation, when P9 reiterated to the defendant that CC1 would be unable to prove his false fraud allegations in court, defendant responded, quote, "The details don't matter," end quote. In the post-election period, P9 also took on the role of updating the defendant on a near-daily basis on the campaign's unsuccessful efforts to support any fraud claims. P9 told the defendant that the campaign was looking into his fraud claims and had even hired external experts to do so, but could find no support for them. He told the defendant that the campaign took these claims to court, they would get slaughtered because the claims were all BS. P9 was privy in real time to the findings of the two expert consulting firms the campaign retained in investigative fraud claims, C1 and C2, and discussed with the defendant their debunkings of all major claims. For example, P9 told the defendant that Georgia's audit disproved claims that C3 had altered votes. In the post-election time period, Pence, the defendant's own running mate, who he had directed to assess fraud allegations, told the defendant he had seen no evidence of outcome determinative fraud in the election. This was in one of many conversations the defendant and Pence had as running mates, in which they discussed their shared electoral interests. So he's separating out that they're running mates so that they're not VP and president, right? So that we don't have official conversations here. Pence gradually and gently tried to convince the defendant to accept the lawful results of the election, even if it meant they lost. These conversations included a conversation on November 4th in which the defendant asked Pence to study up claims on voter fraud in states that they had won together in 2016 to determine whether they could bring legal challenges as candidates in those states. Pence described the conversation as follows, quote, "Well, I think it was broadly, it was just look at all of it. Let me know what you think." But he told me that the campaign was going to fight, was going to go to court and make challenges. And then he just said, "We're going to fight this and take a look. Let me know what you think," end quote. Thank you, Suze. Oh, goodness. I'm just so interested to hear what Pence has to say. A call between the defendant and Pence on November 7th, the day that media organizations began to project Biden as the winner of the election. Pence tried to encourage the defendant as a friend, reminding him, "You took a dying political party and gave it a new lease on life." A November 11th meeting among the defendant, Pence, campaign staff, and some White House staff, during which Pence was asked when most of the lawsuits would be resolved, when does this come to a head? And the campaign staff responded, "The week after Thanksgiving." A November 12th meeting among the defendant, Pence campaign staff, and some White House staff, during which Pence recalls the campaign lawyers gave a sober and somewhat pessimistic report on the state of the election challenges. A private lunch on November 12th in which Pence reiterated a face-saving option for the defendant. "Don't concede, but recognize process is over," end quote. Next, we had another private lunch on November 16th in which Pence tried to encourage the defendant to accept the results of the election and run again in 2024, to which the defendant responded, "I don't know, 2024 is so far off," end quote. A November 23rd phone call in which the defendant told Pence that the defendant's private attorney, P76, was not optimistic about the election challenges. A December 21st private lunch in which Pence encouraged the defendant not to look at the election as a loss, just an intermission. This was followed later in the day by a private discussion in the Oval Office, in which the defendant asked Pence, "What do you think we should do?" Pence said, "After we've exhausted every legal process in the courts and Congress, if we still come up short, the defendant should take a bow," end quote. Ooh, this is new information. Some of this is new, everyone. I have not seen this before. and a discussion in which Pence apprised the defendant of conversations he had had with governors in Arizona and Georgia in the context of election challenges, in which Pence had called the governors simply to gather information and share it with the president, and in which the governors did not report evidence of fraud in the elections in their states and explained that they could not take action to convene their state legislatures. But the defendant disregarded P9 and Pence in the same way he disregarded dozens of court decisions that unanimously rejected his and his allies' legal claims, and that he disregarded officials in the targeted area, including those in his own party, who stated publicly that he had lost and that his specific fraud allegations were false. And then we have 52 here. So we're back into footnotes now, everyone, where we're just citing different pieces down here from different statements that he made. Here's a joint statement in tweets and so on. Election officials, for instance, issued a press release and other public statements to combat the disinformation that the defendant and allies were spreading. At one point, long after the defendant had begun spreading false fraud claims, P15, a White House staffer traveling with the defendant, overheard him tell family members that, quote, "It doesn't matter if you won or lost the election. You still have to fight like hell," end quote. The defendant and his co-conspirators also demonstrated their deliberate disregard for the truth and thus their knowledge of falsity when they repeatedly changed the numbers in their baseless fraud allegations from day to day. At trial, the government will introduce several instances of this pattern. So here's our first time of him saying, this is what we're going to show the jury, everyone, in which the defendant and conspirators' lies were proved by the fact that they made up figures from whole cloth. One example concerns the defendant and co-conspirators' claims about non-citizen voters in Arizona. The conspirators started with the allegation that 36,000 non-citizens voted in Arizona. 5 days later, it was beyond credulity that a few 100,000 didn't vote. 3 weeks later, the bare minimum was 40 or 50,000. The reality is about 250,000. Days after that, the assertion was 32,000, and ultimately the conspirators landed back where they started at 36,000, a false figure that they never verified or corroborated. So we have quite a few sets of numbers here involved in Arizona. Ultimately, the defendant's steady stream of disinformation in the post-election period culminated in a speech he gave at a privately funded, privately organized rally at the Ellipse on the morning of January 6th of 2021, in advance of the official proceeding in which Congress was to certify the election in favor of Biden. In his speech, the defendant repeated the same lies about sorry everyone, edge of our seats here, election fraud in Arizona, Georgia, Michigan, Nevada, Pennsylvania, and Wisconsin that had been publicly or directly debunked. The defendant used these lies to inflame and motivate the large and angry crowd of his supporters to march to the Capitol and disrupt the certification proceeding. Here's part C, everyone, moving forward. The defendant aimed deceit at the targeted states to alter their ascertainment and appointment of electors. So their ascertainment is a legal term that we'll hear repeatedly, as well as the appointment. So these are two terms used when it comes to the electorals, for the electorals of college. Shortly after Election Day, the defendant began to target the electoral process at the state level by attempting to deceive state officials and to prevent or overturn the legitimate ascertainment and appointment of Biden's electors. As president, the defendant had no official responsibilities related to the state's administration of the election or the appointment of their electors, and instead contacted state officials in his capacity as a candidate. So this is a key piece here to his argument. Tellingly, the defendant contacted only state officials who were in his political party and were his political supporters, and only in states he had lost. The defendant's attempt to use deceit to target states' electoral process played out in Arizona, Georgia, Michigan, Nevada, Pennsylvania, and In addition to the following evidence of the defendant's conduct during the charged conspiracies, at trial, the government will elicit testimony from election officials from the targeted states to establish the objective falsity and often impossibility of the defendant's fraud claims. So here's our second piece of what he's saying we're going to offer at trial. Notably, although these election officials would have been the best sources of information to determine whether there was any merit to specific allegations of election fraud in their states, the defendant never contacted any of them to ask. Number one, now we're going to start going through the states, everyone, state by state. In the superseding indictment, we only have a paragraph or two of facts. We have a lot more facts that have been added in this motion. Number one, Arizona. The defendant was on notice that there was no evidence of widespread election fraud in Arizona within a week of the election. On November 9th, for instance, 2 days after news networks projected Biden had won, the defendant called Arizona Governor P16 to ask him what was happening at the state level with the presidential vote count in Arizona. At that point, though Fox News had projected Biden had won the state, several other news outlets, including ABC, NBC, CNN, and the New York Times, had not yet made a projection. P16 walked the defendant through the margins and the votes remaining to be counted, which were primarily from Pima County, which favored Biden, and Maricopa County, which was split. P16 described the situation to the defendant as, quote, the ninth inning, 2 outs, and the defendant was several runs down, end quote. The defendant also raised claims of election fraud, and P16 asked the defendant to send him supporting evidence. Although the defendant said he would, stating, quote, we're packaging it up, end quote, he never did. Shortly thereafter, on November 13, campaign manager P2 told the defendant directly that a false fraud claim that had been circulating that a substantial number of non-citizens had voted in Arizona was false. The same day, as noted previously, campaign attorneys conceded in court that the remaining election lawsuit in Arizona was moot. Right, so he has knowledge now. The defendant and CC1 continued to try to influence P16. For example, CC1 tried to contact P16 on November 22nd. The same day, the defendant and CC1 reached out to the Arizona Speaker of the House, as described below. And on November 30th, the day P16 signed the Arizona Certificate of Ascertainment, formally declaring Biden's electors as the legitimate electors for Arizona. P16 received a call from the defendant and Pence. So Pence was also involved with that. P16 advised them that Arizona had certified the election. When the defendant brought up the fraud claims, P16, eager to see the evidence again, asked the defendant to provide it, but the defendant never did. Instead, later that evening and into the following morning, the defendant repeatedly publicly attacked P16 as well as Georgia Governor P17 on Twitter, retweeting posts by others such as, quote, who needs Democrats when you have Republicans like P17 and P16, end quote. And, quote, watching the Arizona hearings and then watching Governor P16 sign those papers, why bother voting for Republicans if what you get is P16 and P17? And, quote, P17, my state ran the most corrupt election in American history. P16, hold my beer. And why is P16 still pretending he's a member of the Republican Party after he just certified fraudulent election results in Arizona that disenfranchised millions of Republicans? Oh, yikes. That's a lot. All right. The defendant and co-conspirators also attempted to use false fraud claims to convince political allies in the Arizona state legislature to ignore the popular vote and appoint illegitimate electors. On November 22nd, the defendant and CC1 called P18, the Speaker of the Arizona House of Representatives. CC1 did most of the talking. During the call, the defendant and CC1 levied multiple false fraud claims, including of non-citizens, non-residents, and unalive voters that affected the defendant's race, and asked P18 to use them as a basis to call the state legislature into session to replace Arizona's legitimate electors with illegitimate ones for the defendant. When P18 voiced his deep skepticism, CC1 said, well, you know, we're all kind of Republicans and we need to be working together. P18 refused and asked CC1 to provide evidence supporting his fraud claims. CC1 never did. Right. So if you think something illegal is going on, do you usually go to the House of Representatives or do you go to law enforcement? I'm just going to put that out there. Just putting that out there. Here we go. Moving on. Indeed, CC1 met with P18 in person approximately a week later and still had nothing to back up his claims. On November 30th, CC1 and P12 and others arrived in Arizona for a hotel hearing, an unofficial meeting with Republican legislators, during which they promoted false fraud allegations. In a meeting the day after the hearing, when state legislators pressed CC1 and P12 for evidence to support their claims, CC1 conceded that even on that late date, quote, "we don't have the evidence, but we have lots of theories," end quote. That's a great quote. When the legislators were frustrated that CC1 had no support for his claim and asked him tough questions, CC1 expressed surprise at the way he was being treated, stated, "Man, I thought we were all Republicans. This is a little more hostile a reception. I'm amazed at the reception I'm getting here," end quote. On December 4th, P18 released a public statement in which he explained he did not have the authority to use the legislature to reverse the results of an election, and that doing so would constitute an attempt to nullify the people's vote based on unsupported theories of fraud. Tea break. Thanks, Anne. Oh, you read my mind. Yes, indeed. P18 made clear that he was disappointed with the legitimate election results because he voted for President Trump and worked hard to reelect him, but would not violate current law to change the outcome of a certified election. On Twitter, P19, a campaign staffer who worked with CC6, and attacked P18 for his statement, writing that P18 is intentionally misleading the people of Arizona. To avoid the inevitable, the defendant retweeted P19's false post and praised her. A month later, just 2 days before January 6th, CC2, another of the defendant's private attorneys and a co-conspirator, called P18 and P18 counsel P20 and urged P18 one last time to use the legislature to decertify Arizona's legitimate electors and overturn the valid election results. When P18 and CC2 told CC2 that there was no evidence of substantial fraud in Arizona and that he could not legally call the legislature into session, CC2 was undeterred. He conceded that he didn't know enough about the facts on the ground regarding fraud in Arizona and said that P18 would nonetheless falsely claim that he had the authority to convene the legislature and let the court sort it out. Again, refused. In the post-election period, P18 was harassed. On several occasions, individuals gathered outside P18's home with bullhorns and screamed and honked their vehicle horns to create noise. Once an individual in visible possession of a pistol and wearing a t-shirt in support of a militia group came onto P18's property and screamed at him. At the time of these events, P18's daughter was at home and was very ill, and the noise caused her disruption and angst. Oh, that's sad. Number 2, Georgia. All right, are we ready for Georgia, everybody? We're moving into Georgia. Yes, we have all of the names of all of the witnesses redacted due to the protective order that's on file here. All right, here we go. The defendant had early notice that his claims of election fraud in Georgia were false. Around mid-November, campaign advisor P4 told the defendant that his claims that a large number of unalive people had voted in Georgia was false. The defendant continued to press the claim anyway, including in a press appearance on November 29th, when he suggested that a large enough number of unalive voters had cast ballots to change the outcome of the election in Georgia. 4 days later, on December 3rd, CC1 orchestrated a presentation to a judiciary subcommittee of the Georgia State Senate. In the morning, in advance of it, CC1 had spoken to the defendant on the phone for almost 20 minutes. And at the hearing, CC1 arranged for co-conspirators and agents to repeat the false unalive voter claim. The claim was so patently false that everyone around the defendant knew it. During the hearing, Chief of Staff P21 and P9 exchanged text messages on their personal phones, confirming that a campaign attorney, P22, had verified that CC1 the claim of more than 10,000 unalive voters. Whoops, sorry everyone, puzzle piece, just one moment. Did we get it? Oh, we got it. Okay, we're verified. All right, here we go. Claim of more than 10,000 unalive voters was false, and that the actual number was around 12 and could not be outcome determinative. During the subcommittee hearing, the conspirators also set in motion a sensational and dangerous lie about the election workers at State Farm Arena that would result in the defendant's supporters harassing and threatening the workers. First, P23, one of the defendant's private attorneys, claimed that more than 10,000 unalive people had voted in Georgia. Next, P24, an agent of the defendant, played misleading excerpts of a closed-circuit camera footage from the State Farm Arena and insinuated that it showed election workers committing misconduct, counting suitcases of illegal ballots. Lastly, based on the false fraud allegations, CC2, who had already been engaged as a private lawyer for the defendant but did not disclose that at the hearing, encouraged the Georgia legislators to decertify the state's legitimate electors. Oh, thank you so much for the likes, everyone. I appreciate that. While the hearing was ongoing, the defendant simultaneously amplified the misinformation about the State Farm Arena election workers, falsely tweeting, quote, "Wow, blockbuster testimony taking place right now in Georgia. Ballot stuffing by Dems when Republicans were forced to leave the large counting room. Plenty more coming, but this alone leads to an easy win of the state," end quote. He did this just after retweeting two of his campaign account's tweets that promoted the false claim about election workers at the State Farm Arena. Over the next week, the claims of misconduct at State Farm Arena were disproven publicly as well as directly to the defendant. The day after the hearing, P25, the chief operating officer of the Georgia Secretary of State's office, posted a tweet explaining that Secretary of State officers had watched the video in its entirety and confirmed it showed normal ballot processing. P25 again forcefully debunked the conspirators' claims about the State Farm video in a press conference on December 7th, explaining at length the election workers' innocent conduct depicted in the closed-circuit camera footage and stating, so we have a direct statement here, and what's really frustrating is the president's attorneys had this same videotape. They saw the exact same things the rest of us could, and they chose to mislead the state senators in public about what was on that video. I'm quite sure that they will not characterize that video if they try to enter it into evidence, because that's the kind of thing that would lead to sanctions, because it's obviously untrue. They knew it was untrue, and they continue to do things like this, end quote. On December 8th, the defendant called Georgia Attorney General P26. P26 had advanced notice that the topic of the call was Texas versus Pennsylvania, an election lawsuit in which Texas was suing other states, including Georgia, to attempt to prevent the certification of the election. U.S. Senator P27 told P26 that the defendant had heard P26 was whipping or lobbying other state attorneys generals against filing amicus briefs in support of Texas. P26, there were a lot of people that signed on to the amicus brief, by the way, in that situation. P26 was not lobbying against the suit and told P27 so. P27 asked P26 if he would speak with the defendant about it, and P26 agreed. Shortly thereafter, the defendant called P26 and immediately raised Texas v. Pennsylvania, saying, quote, "I hope you're not talking to your AGs and encouraging them not to get on the lawsuit," end quote. P26 told the defendant that he was not affirmatively calling other state attorneys generals, but if they called him, he was telling them what he was seeing in his state, which was something the defendant probably did not want to hear. P26 was just not seeing evidence of fraud in Georgia. The defendant nonetheless raised various fraud claims. P26 told him that state authorities had investigated the State Farm Arena allegations and found no wrongdoings, that he thought another claim the defendant raised let's go back. Allegations and found no wrongdoing, and that he thought another claim the defendant raised about Coffee County, Georgia, had been similarly resolved but would check. So we're still in Georgia, everybody. The defendant asked P26 to look at them again because we're running out of time. P26 tried to steer the call to an end by thanking the defendant and telling him that he had voted for him twice and appreciated the defendant, to which the defendant responded, quote, "Yeah, I did a hell of a job, didn't I?" End quote. At one point, the defendant raised with P26 the impending runoff election for Georgia's U.S. Senate seats and how important it was to re-elect P27 and P28. The day after the call, the defendant, in his private capacity as a candidate for president, intervened in support of Texas versus Pennsylvania. His attorney, for that matter, was CC2. Now, as just a side note, everybody, when he filed that intervention, he literally put in the caption, his private capacity. Just an FYI if you want to pull that case and take a look at it. On the same day as defendant's call with P26, the defendant's campaign staff acknowledged the State Farm Arena claim was unsupported, emailing one another about the fact that the television networks may decline to run campaign advertisements promoting it. In frustration regarding the claim and the like, P4, who spoke with the defendant on a daily basis and had informed him on multiple occasions that various fraud claims were false, wrote, quote, "When our research and the campaign legal team can't back up any of the claims made by our elite strike force legal team, you can see why we're 0-32 on our cases. I'll obviously hustle to help on all fronts, but it's tough to own any of this when it's all just conspiracy shit beamed down from the mothership." Oh dear. Language. That's a direct quote, TikTok. On December 10th, however, CC1 further perpetuated the false State Farm Arena claim when he appeared at another hearing, this one before the Georgia House of Representatives Government Affairs Committee. During it, he displayed some of the same footage as had been used on December 3rd, the December 3rd hearing that had been debunked in the interim by Georgia officials, and nonetheless claimed that it showed voter fraud right in front of people's eyes, end quote. He then named two election workers, P29 and her mother, P30, and baselessly accused them of quite obviously surreptitiously passing around USB ports as if they were vials of heroin or cocaine, direct quote, and suggested that they were criminals whose places of work, their homes, should have been searched for evidence of ballots, for evidence of USB ports, for evidence of voter fraud. As these false claims about P30 and P29 spread, the women were barraged by racist unalive threats. In the years since, they have spoken about the effect of the defendant and co-conspirators' lives about them. And P30 explained in an interview with congressional investigators, when someone as powerful as the President of the United States eggs a mob on, that mob will come. They came for us with their cruelty, their threats, their racism, and their hats. They haven't stopped even today, end quote. Indeed, to this day, the defendant has never stopped falsely attacking P30 and P29. Although none of the false claims against them were ever corroborated, the defendant has continued to levy them on social media, including when the defendant attacked P30 in January of 2023, just after her testimony to congressional investigators was made public. So this is still going on. Throughout the post-election period, the defendant used Twitter to publicly attack Georgia Governor P17 with particular aggression. In the 35 days between November 30th and January 3rd, the defendant tweeted critically about P17 by name or title more than 40 times. These tweets included the ones also attacking P16 described above, as well as others particular to P17, like, quote, "Why won't the governor at P17, the hapless governor of Georgia, use his emergency powers, which can be easily done to override his obstinate Secretary of State?" Oh my gosh, I don't remember reading this one. "And do a match of signatures on envelopes. It will be a gold mine of fraud, and we will win the state. I will easily and quickly win Georgia if the governor at P17 or the Secretary of State permit a simple signature verification has not been done and will show large-scale discrepancies. Why are these two Republicans saying no? If we win Georgia, everything else falls in place, end quote. Quote, the Republican governor of Georgia refuses to do signature verifications, which would give us an easy win. What's wrong with this guy? What is he hiding? End quote. And quote, how does Governor P17 allow certification of votes without verifying signatures? And despite the recently released tape of ballots being stuffed, his poll numbers have dropped like a rock. He is finished as governor, end quote. Yikes. In the post-election period, the defendant also made false claims in court about fraud in Georgia unsuccessfully. For example, in Trump v. Kemp, a federal lawsuit in which the defendant and Georgia's governor and secretary of state, the defendant cited verification of fraud allegations that he and his attorney on the case, CC2, knew were inaccurate. P9 spoke with the defendant and CC2 in late December regarding the proposed verification. First, he told CC2 and another private attorney, P31, that they could not have the defendant sign it because they could not verify any of its facts. Well, that's important. So they told him not to sign it. Oh my goodness. And P9 told the defendant that any lawyer that signed the complaint that the verification supported would get disbarred. Well, and that's true. CC2 acknowledged this problem in an email on December 31st. So this is new information, everyone. To P32, lead counsel for the defendant as candidate in Trump v. Kemp, and another private attorney writing that in the time since the defendant signed the previous verification in the case, he had been made aware of some of the allegations and evidence proffered by the experts has been inaccurate, and that the signing a new affirmation with that knowledge and incorporation by reference would not be accurate. Nonetheless, on December 31st, the defendant signed the verification and caused it to be filed. Oh dear. Well, that does show some knowledge, I think. On January 2nd, Georgia Secretary of State P33 appeared on Fox News and said that various rumors of election fraud were false and the defendant had lost in Georgia. Our office has been very busy with what I call the rumor whack-a-mole. Every day a rumor will pop up and then we whack it down. What we do, we basically whack it down with the truth. And people can't handle the truth sometimes because they're very disappointed in the results. And I get that. I voted for President Trump also. But at the end of the day, we did everything we could. We did an audit of the race. President Trump still lost. Then we did a full recount. President Trump still lost. We had a safe, secure process. End quote there. That's interesting. Tea break, yes, thank you. I was just reaching for it. P33, like P17, had been on the receiving end of the defendant's tweets. These included, quote, why isn't the Georgia Secretary of State, a so-called Republican, allowing us to look at the signatures on envelopes for verification? We will find tens of thousands of fraudulent illegal votes. Rhinos at P17 and P34 and Secretary of State P33 will be solely responsible for the potential loss of our two great senators from Georgia. At P27 and P28 won't call a special session or check for signature verification. People are angry. In Georgia, where is signature verification approval? What do you have to lose? Must move quickly at P17 and P34, Georgia Secretary of State. Shortly, and again, as former prosecutor, this is odd to me that someone would just go in and start talking about something like they're saying, like, why didn't the grocery store clerk pat you down correctly? Like, what? What are you talking about? That's not your job. Shortly after seeing the interview, the defendant set up a call with P33 to discuss his pending private lawsuit, Trump v. Kemp, in which P33 was named a defendant. For this reason, P33 at first hoped to avoid speaking with the defendant, but ultimately acquiesced because the defendant was persistent in seeking to set it up, also because of the pending lawsuit. P33 arranged for his general counsel P35 to participate. Joining the defendant on the call were Chief of Staff, P21, and 3 private attorneys, P32 and P36, Counsel of Record, and Trump v. Kemp, and the attorneys whom CC2 had emailed about the defendant's false verification, and P31, whom P21 introduced on the call as someone who is not the attorney of record but has been involved, end quote. The defendant began the call. Here's the call, everybody. All right, here's the call. The defendant began the call with an animated monologue in which he argued that he had won the election in Georgia, saying, quote, "Okay, thank you very much. Hello, P33 and P35, and everybody. We appreciate the time in the call. So we've spent a lot of time on this, and if we could just go over some of the numbers, I think it's pretty clear that we won. We won very substantially, Georgia," end quote. Throughout the call, the defendant continued to state that he had won and referenced Biden's margin of victory that he needed to overcome to prevail in the state, including by asserting that, "I just want to find 11,780 votes," end quote. He did not reference other elections on the same ballot. After the defendant's opening salvo, P33 stated, "Well, I listened to what the president has just said. President Trump, we've had several lawsuits, and we've had to respond in court to the lawsuits and the contentions. We don't agree that you have won." The defendant raised multiple false claims of election fraud, each of which P33 refuted in turn. When the defendant attacked P30, called her a professional vote scammer, oh dear, it's not very nice, and hustler, oh my goodness, and mentioned her dozens of times throughout the call, P33 said, quote, "You're talking about the State Farm Arena, and I think it's extremely unfortunate that CC1 or his people, they sliced and diced that video and took it out of context," end quote. He then offered the defendant a link to the video disproving the claim, to which the defendant responded, quote, "I don't care about a link. I don't need it. I have much. P33, I have a much better link," end quote. When the defendant claimed that 5,000 unalive people had voted in Georgia, P33 said, "Well, Mr. President, the challenge you have is the data you have is wrong. The actual number were two people that were unalive that voted. And so that's wrong. That was 2. When the defendant claimed that thousands of out-of-state voters had cast ballots, P33 responded, "We've been going through each of those as well, and those numbers that we got, that's Ms. P31 was just saying, they're not accurate," end quote. So again, famous phone call. You can look it up on the Tube of You for anyone that would like to listen to that phone call again. At one point, the defendant became frustrated after both P33 and P35 explained repeatedly that his claims had been investigated and were not true, and stated, quote, "And you're not going to find that they are, which is totally illegal. It's more illegal for you than it is for me. You know what they did. You're not reporting it. That's a criminal. You know that's a criminal offense. And you know you can't let this happen. That's a big risk to you. And P35, your lawyer, that's a big risk," end quote. The call ended with P35 stating that he would coordinate with the lawyers representing P33 office in a private lawsuit and get together with P32 as agreed earlier in the call. The day after the call on January 3rd, the defendant falsely tweeted, "I spoke with the Secretary of State, P33, yesterday about Fulton County and the voter fraud in Georgia. He was unwilling or unable to answer questions such as ballots under the table, scam, ballots destruction, out-of-state voters, unalive voters, and more. He has no clue!" Exclamation point. End quote. Promptly responded in a tweet of his own, quote, "Respectfully, Mr. President, what you're saying is not true. The truth will come out," end quote. So that was Georgia, everybody. Oh my goodness. All right. Next up is Michigan. Number 3. On November 20th, 3 days before Michigan's governor signed a certificate of ascertainment appointing Biden's electors based on popular vote, the defendant met with P37 and P38, Michigan's Senate Majority Leader and Speaker of the House, at the Oval Office. The defendant initiated the meeting by asking RNC Chairwoman P39 to reach out to P38 and gauge his receptivity to a meeting. The defendant also asked P39 to participate in the meeting, but P39 told him she had consulted with her attorney and that she could not be involved in a meeting with legislators because it could be perceived as lobbying. After P39 made first contact on November 18th, the defendant reached out to P37 and P38 to extend an invitation. That same day, he contacted P37 and P38. The defendant issued a false tweet. In Detroit, there are far more votes than people. Nothing can be done to cure that giant scam. I win Michigan. When the defendant called P37 and P38 to invite them to the White House, he did not provide the topic of the meeting, but he did ask about allegations of fraud in the election in Michigan. The legislators told him that they in the Michigan legislature were examining the allegations. Both P37 and P38 assumed that the defendant wanted to see them to discuss claims of election fraud, and they wanted to be firm that they had not seen any evidence that would change the outcome of the election. For this reason, and to avoid talking only about election fraud, they prepared materials to raise regarding COVID-19 and planned in advance to release a statement once the meeting was over that said the legislators were unaware of information that could change the outcome of the election. Over the course of the meeting, the defendant dialed in both P39 despite her request not to participate, and CC1. P21 was present for some, but not all of the meeting. After some small talk with the legislators in the Oval Office, the defendant raised various fraud claims, including that he lost Michigan because of fraud or misconduct in Wayne County, where Detroit was located. P37 corrected the defendant and told him that he had lost primarily because in two routinely Republican counties, the defendant had underperformed with educated females. And if he had received the same number of votes there as the two winning local sheriffs, he likely would have won Michigan. Oh my gosh. P37 could tell the defendant's body language that he was not happy to hear P37's assessment. Notably, the defendant only raised fraud claims to the extent that they affected the outcome in his own race and not those for other races in Michigan. I think that's really pivotal, everyone, that if we're looking for voter fraud and it's only affecting one race, not all of the races. CC1's participation came after the legislators assured the defendant that they were looking into the fraud claims. The defendant dialed CC1 into the meeting and said, "CC1, tell them what's going on." CC1 then launched into a fraud monologue. Remember, CC1 has lost his law license in New York and in D.C. Finally, P37 interrupted and asked, quote, "So, when are you going to file a lawsuit in Michigan?" A question that CC1 ignored and did not answer. Immediately after the meeting, P37 and P38 released a public statement in which they stated they had not yet been made aware of any information that would change the outcome of the election in Michigan. On November 21st, the defendant acknowledged P37 and P38's statement when he tweeted, quote, "This is true, but much different than reported by the media," end quote, and implicitly conceded that he had not provided evidence of fraud, yet when he added, quote, "We will show massive and unprecedented fraud," end quote. Days later, the defendant's campaign declined to request a statewide recount in Michigan, for which it would have had to pay unless the recount succeeded in changing the outcomes of the election. So I think that's important. I'm wondering what effect that will have on the jury to say, they refuse to ask for a recount here. I think that's interesting point. Despite failing to establish any valid fraud claims, CC1 followed up with P37 and P38 and attempted to pressure them to use the Michigan legislature to overturn the valid election results. On December 4th, CC1 sent a message to P38 claiming that Georgia was poised to do so, based on CC1 and CC2's false advocacy there in the December 3rd hearing, and asked P38 for help. Quote, "Looks like Georgia may well hold some factual hearings and change the certification under Article 3, Section 1, Clause 2 of the Constitution. As CC2 explained, they don't just have the right to do it, but the obligation. Help me get this done in Michigan," end quote. On December 7th, CC1 attempted to send P37 a message, though failed because he typed the wrong number into his phone. Oh dear. Quote, so I need you to pass a joint resolution from the Michigan legislature that states that the election is in dispute. There's an ongoing investigation by the legislature, and the electors sent by Governor Whitmer are not the official electors of the state of Michigan and do not fall within the safe harbor deadline of December 8th under Michigan law, end quote. Campaign operative, this is a quote you don't want to have accidentally going to the wrong person. Campaign operative P5 was involved in the drafting of this message with the assistance of P41, who was associated with defendant's campaign efforts in Michigan. The following day, CC1 shared the draft with the defendant, sending it to his executive assistant, P42, by email. Oh my goodness. Those efforts failed. On December 14th, the day the duly appointed electors across the country met and cast their electoral votes, P37 and P38 issued public statements confirming the defendant had lost Michigan, and the legislators still had not received evidence of outcome determinative fraud in their state. P37's public statement included, quote, we've not received evidence of fraud on a scale that would change the outcome of the election in Michigan, end quote. P38 stated in part, yes, tea break. Sorry, everybody. Here we go. We've diligently examined these reports of fraud to the best of our ability. I fought hard for President Trump. Nobody wanted him to win more than me. I think he's done an incredible job, but I love our republic too. I can't fathom risking our norms, traditions, and institutions to pass a resolution retroactively, changing the electors for Trump, simply because some think there may have been enough widespread fraud to give him the win. That's unprecedented for good reason, and that's why there's not enough support in the House to cast a new slate of electors. I fear we will lose our country forever. This truly would bring mutually assured destruction for every future election in regards to the Electoral College, and I can't stand for that. I won't, end quote. On January 3rd, the defendant's campaign publicly posted P37's phone number and attempted to post P38, but erred by one digit. In a tweet urging contact Speaker P38 and Senate Majority Leader P37, P37 received 4,000 text messages in 2 hours, forcing him to get a new phone number. Oh, that's not very nice. That's not nice at all. All right, here's Nevada, everyone. We're moving through the states. On November 17, in Law v. Whitmer, agents of the defendant in Nevada filed suit, claiming substantial irregularities, improprieties, and fraud in the presidential election, including based on machines used in ballot signature matching and votes by non-resident and unalive voters. The defendant approved a press conference by his surrogates announcing the suit. On November 19th, P43 at the RNC Chief Counsel sent an email to P44, an RNC spokesperson, warning about inaccuracies in the suits. Quote, just FYI, I don't believe the claims in the contest regarding unalive voters. Those voting from out of state, etc., are substantiated. We were working with the campaign on a data matching program, and those numbers are going to be a lot lower than what the NV people have come up with. They are also targeting our military voters. To be frank, the contest has little chance of succeeding. Happy to discuss this stuff if you want more info, end quote. P44 then sent a copy to P43 email from her personal email account to the personal email account of P45, one of the defendant's White House staffers who also volunteered for the campaign. Are we figuring out who all the people are, everyone? As we go through this, notwithstanding the RNC Chief Counsel's warning, the defendant retweeted and amplified news of the lawsuit on November 24th, calling it, quote, big news, that a Nevada court had agreed to hear it. But the defendant did not similarly promote the fact that within 2 weeks, on December 4th, The Nevada District Court dismissed Law v. Whitmer, finding in a detailed opinion that, quote, there's no credible or reliable evidence that the 2020 general election in Nevada was affected by fraud, end quote, including through the signature match machines, and that Biden won the election in the state. 4 days later, on December 8th, Nevada Supreme Court unanimously affirmed the district court's decision, noting that despite its earlier order asking appellants to identify specific findings with which they take issue, appellants have not pointed to any unsupported factual findings, and we have identified none. Later, in his ellipse speech on January 6th, the defendant repeated multiple claims explicitly rejected by Nevada courts. On December 18th, the Nevada Secretary of State's office released a facts versus myths document to combat disinformation that the defendant and others were propagating about the election, including false claims the Secretary of State's office had not investigated claims of fraud, even though it had been presented with evidence of widespread fraud, to which the office responded, quote, while we're pursuing action in a number of isolated cases, we have yet to see any evidence of widespread fraud. The Facts versus Myths document also stated publicly that the courts had universally rejected fraud claims. 4 separate cases were heard by Nevada judges, including Nevada Supreme Court. After examining records presented, each case was discounted due to lack of evidence. And with that, everybody, I have made it to page 37. We can do a little Q&A here, but I will have to stop my reading for tonight. That's been quite a bit. I will pick up again at the same time tomorrow to continue to go through the states. We have the last of the states, and then we have next up his legal interpretation of the immunity case. So with that, oh, thank you. Thank you for the presents. Oh, thank you. I tell you what, the amount of ink it took to print. This was a lot. Oh, you're most welcome. You're most welcome. It's very interesting. I think it's very interesting. We have several pieces that are new, several pieces that were in the original indictment that are no longer in the superseding indictments. So this is more of just kind of a facts, setting out the facts for us here. So time tomorrow, we will do 7 o'clock Central, everyone. We'll come back. We'll do another take 2. So it'll be 7 o'clock Central. We'll go again. We'll probably do about 90 minutes. Is probably about the max I can do with my voice, and I'll just take you through the next big section. Oh yeah, absolutely, my pleasure. It's very interesting walking through it. It's taking a bit of time to get through our facts here, but I think it's important to go line by line so that we don't miss anything that might be new. So Ginny's not in the document yet. No, no, she's not. She's not. So far we have. Again, the introduction where he set out his 4 pieces, how he's divided up his motion, Jack and his team here. Then we have our factual proffer, which is what I have been going through, where he has set out kind of his introduction piece, the formation, how the conspiracies got started, and then we started going into the individual states. He does go and list each individual state in the superseding indictment, so I think it's great that he's coming in and adding more facts, more information here in his filing as well. So we've made it through almost everything. We still need Pennsylvania. So what's the goal of this filing? So this is the filing, and we're kind of in uncharted territory here because this is kind of a weird situation where the Supreme Court has set out what they want to see. And this is the motion for immunity determinations. The whole goal of this is that they have to determine whether or not Trump's actions listed in the superseding indictment were official acts or unofficial acts. Because if they are official acts, that's where we've got immunity issues going on. Unofficial acts are not. So what Jack is saying here is that how we set it out in the superseding indictment, every word we have set out, none of that is covered by immunity. None of that is included. And so we're going to show you why. Who added the redactions? So the first set of redactions would have been submitted to the court. So Jack would have included them. Now Mr. Trump would have had to go through. He had a filing that was due to have his decision on redactions on Tuesday, which is why we have this brief today. So his redactions were filed yesterday, and so now we've got both sets. Both parties have agreed to the redactions that are on here. So Jack Smith's team and Mr. Trump's team have agreed to the redactions that are in here in order for us to be able to see it publicly. Do I think Trump will go to prison? No way to know. No way to know. I can't say that for any defendant. There's just no way to know with a jury case. No matter how good your case is, it's 50-50, no matter what. It's just 50-50. And you may think you have the strongest case in the entire world, and it may be a not guilty. Or you may think that your case is thin, real thin, and you may get a full conviction. There's just no way to know. Anytime you take a case to a jury, you're spinning the wheel, and it's 50-50 no matter what. So I say that for any jury case, it's 50-50. 50-50, yeah. The judge will make the determinations at this point. This is pre-trial, right? This is before our jury's even selected any of that, because in order to go forward, we have to figure out what's on the table for the jury to even decide. So that's why we're trying to figure out what was covered, what wasn't covered by immunity, and that's because of how John Roberts wrote the decision that came out of the Supreme Court. Oh my gosh, 515th. Oh my gosh, everybody, thank you so much. Thanks for the likes. Unofficial acts means he acted as a candidate. Yeah, that's the question. The unofficial acts are going to be where if you've got official acts as the president, and then you have unofficial acts as just whomever. It doesn't matter. They're just unofficial, so they don't count anymore. And then you have acts of a president and then acts of a candidate. So it's kind of a two-tiered process. We have president versus candidate and official versus unofficial. So you have to go through both of the analysis in those. You can Google this. Yes, you most certainly can. And there is a really great document too. If you put in immunity chart, so presidential immunity chart, and there are several different websites that have charts of the process, the step process that you need to go through in order to determine immunity. So that can be helpful if you need a visual picture of that. I don't have that on me at the moment. Why is it taking so long? Well, yeah. Yes, very, very long time. Very, 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 very long time. Quite a bit. Quite a bit of a long time. And it'll continue. It'll continue. They all seem to be as candidate, not president. Well, and that's what Jack's arguing here. He's arguing in every single thing. And again, let me just get this superseding indictment out. We have one defendant listed in the superseding indictment. Mr. Trump's the only defendant. We have 4 counts here. We have conspiracy against rights, but we've got obstruction, defrauding here, official proceeding, and against rights. So for each one of these counts, they have to have probable cause to support it, right? So they're like, these are the set of facts that I've got as probable cause, say Mr. Trump violated this law. So based off of that, they're saying the probable cause that has led to these charges being filed, all of those acts, all of those facts are unofficial. Those are not anything that had to do with him being the president. They had to do with him being a candidate for the president. So anything we've listed in our indictment, anything here is all fair game because none of it was official. Not a single bit of it was. And because it's not official, it's not included under the immunity decision. That's what Jack's arguing. So every single word in here, none of it is official. Only official presidential act was whether or not he called the National Guard. Could be. There was some discussion on whether or not his talking with people from the DOJ, talking with people in his office, talking with, Mike Pence. Maybe those were official duties as president. One of your jobs is to, run the executive branch. Maybe that was an official act. But what Jack is saying in here is the content of what they were saying is rebuttable as any kind of an official act because it had to do with him being a candidate. So it's not included. Yes, October is going to be busy. It's going to be October will be a very busy month, for sure. We have also tomorrow another filing. Mr. Trump's got another filing due tomorrow. regarding the motion to dismiss that he had filed. We had several motions to dismiss that were still going in the DC case, and so he's got a cleaned up one that he needs to file tomorrow for the superseding indictment. So that will be filed tomorrow. And then that Blessing Game case that Jack's already mentioned, which I think will play a huge role in this case in deciding what's immunity and what's not immunity, is this Blessing Game case, which was incredibly well written, the civil case. So they've got a joint status report on Friday. So that case will also be going through the same question on immunity. It will just be in a civil context. So we are kind of at the same time running two cases asking the same questions when it comes to immunity. So it'll be very interesting to see how it plays out. Right. Oh, Judge Cannon. Oh, yeah. She's in Florida. Yeah, she's not here. She's not in D.C. We don't have her in D.C. Yikes. What's the penalty for all of these charges if he was convicted? I do not have a list set out for that. We've got violations here. I think it wasn't a lot. It seemed like it wasn't a lot. I thought we were looking at 2 5s, a 10, and a 20, but I can't guarantee that. So I'm not exactly sure. The most amount of time he was looking at in one single indictment was the Florida indictment. So there really wasn't that much prison time on the table here. It might have only been 5 years a pop, come to think of it. Obstruction's a decent number of years. Yeah, I'm wondering. It seems like one of these had quite a bit, but the other conspiracies were, 5 years. So I'm not exactly sure. Trial date, great question. We're way too early on because this is a pretrial motion that we're dealing with. We are even way ahead of even a pretrial schedule. Until this immunity is decided, they can't even go into like their motions in limines or they haven't finished up their discovery motions either. So discovery is still being fought over and all of that. So we're just way too far out to know any kind of a trial date at this point. Back in the office, can you make all this go away? Well, I mean, I don't know. It's a good question. It's a good question. I mean, the DOJ doesn't work like, Star Wars. Like the emperor doesn't come in and say, like, stop all the lawsuits. Like it doesn't really function that way. But I mean, if there is still a pecking order that is involved. So I'm not sure exactly how it will go if he were to get into office. It certainly won't be a smooth road. Tell you your life stuff helped me through. Oh, I'm so glad, Casey. Oh, that's so kind of you to say. Oh, that just makes my day. I'm just trying to help as much as I can. I think this can be so confusing how all of this stuff works if you haven't been in it. So, I'm so glad to hear that. Congrats. I love that. It continues. Well, right. I think at some point, I'm not sure you even can distinguish between the truth and a lie. That's one of our questions that we have for whether or not you're actually competent to testify. Competency doesn't necessarily mean you have some kind of a mental issue as far as a scientific diagnosis. It can be something like, can you tell the difference between the truth and a lie? And if you cannot, technically the legal standard would be you would be incompetent to testify. So I asked that question a lot of Mr. Trump. Can he tell the difference between a truth and a lie? And I'm not sure that he can. And I truly believe that we've got a competency issue going on with him, in my opinion. In my opinion, of course, I don't have him on the stand. I'm not, asking him questions, but I would say we definitely have some issues. And if he does know the difference between a truth and a lie and chooses to tell a lie instead of the truth, I mean, that's a little different issue. But I think sometimes when you have a pathological liar situation, you create your own reality, and then that really starts to become your reality. So, I don't know. I don't know about that. He knows he doesn't care. Could very well be. Hard to know what's going on in his head, hard to know. We can guess for sure, but, again, unless he was in front of me and I was asking him a question, this will set precedent, absolutely. This is all setting precedent. This is the first time we've had the Supreme Court set out, like, I'm going to give immunity to someone like this. but I don't know exactly what it's going to mean. I'm going to make you decide, and then you're going to have to appeal it back up to me, and then I'm going to decide if I like what you decided, kick it back down to you to try again. It's like, what are you doing, John Roberts? What are you even doing? So this is a very unique situation. Whatever happens here will set precedent, but whatever happens will be appealed. All right, it'll be appealed up to the Court of Appeals, the DC court, and then it'll get appealed up to the Supreme Court, and then it'll get kicked back down, and then they'll go through it again. So it'll be just kind of like cycling through until John Roberts gets something that he's comfortable with. Didn't he recently admit he lost? He did, yeah, he did. Justice is part of, well, I don't know. I mean, when you start talking about justice, that's a difficult question. I mean, how to truly get to justice is a difficult question. Right, just like accountability. What exactly is accountability? Some people think accountability, the only way to have accountability is prison. And some people think, accountability looks like, I caught you and there's an acknowledgement of wrongdoing or a changing of behavior. I mean, it depends. Everybody looks at it kind of differently. So I think that's a little bit different. Oh yeah, it's all for sure. Does that loss admission not apply? Well, I think what Jack's team here is trying to show is his intent. Like, he knew he lost. So by coming in and saying, all of this was because I really thought there was fraud, like I really did, and I was all doing this with the best of intent because I truly believed there was fraud. And it's like, well, no, you didn't. Like, you knew you lost. So what was your intent? You had a negative intent involved. You did it on purpose. And so, that's really what they're trying to show. And any kind of statement that can come in regarding that, they would definitely use to get that intent element. So any kind of admission that he would make could be used, absolutely, as long as they could get it into court appropriately. And I would use it, absolutely, in order to show that intent again, to say, hey, and, again, when we were going through Giuliani's disbarment, where he's like, well, it was just a good faith misunderstanding, or I just didn't, at the time, I really believed that this was true. And, what they're finding is like, that's just not even true. Like, those words aren't even true, sir. Like, you knew that it wasn't true at the time, and you kept going forward nevertheless. So, that's a piece that Jack's going to have to really fight with. He's going to need to kind of show that. Like, you knew this wasn't oh dear, I just kind of mixed this up and I was doing the best thing I could for the country, blah, blah, blah. Like, no, you knew you had lost. This was wrong. You kept going anyway. And that element is going to pull that conspiracy piece in and that intent piece that he needs. Hi from Salem. Hello, welcome. She hasn't been a prosecutor for a long time. Somebody said, I want to see Kamala prosecute this. She hasn't been a prosecutor for a long time. You get rusty, everybody. You get rusty. I mean, I've got nothing but respect for people that have put their time in the trenches, but you get rusty. You don't want to go back in that courtroom again after you've been out of it for a while. Oh my gosh, somebody would be like, oh, you're so sweet to say that. Oh, I'm happy to come on and help as best I can. It's overwhelming when you don't know how it works, right? It's overwhelming when they just kind of throw it at you like, whoa, this huge thing just dropped and it's such a big deal. And it's like, well, why is it a big deal? Why is it? Let's go through and talk about it. Let's go through. She'll be president. Well, right. I mean, right. But, just in general, I would say anyone who's been an attorney, it's like, you got to take a little time. Why redact names? We can kind of tell who they are. Great question, Kel. And that's because there is a protective order in place. And it was actually the DC protective order, everyone, that set the standard for our New York cases, right? We had the criminal case as well as the civil case in New York, and there were protective orders put into place. And Judge Engeron and Judge Merchan both used the DC protective order as their template. So she had set out a protective order to protect their witnesses here and to protect, their court staff and their the attorneys, and that was held to be constitutional and absolutely fine. So because of that, that's why the names are redacted. It's because of the protective order. Oh, Kristen, you're so sweet. Can the Supreme Court decide not to hear it? Yes, they can. They most certainly can. What'll happen is it'll get appealed to the Court of Appeals for the DC Circuit, right? The DC Circuit will decide, like they did on the immunity case when they said no one was above the law. And then the Supreme Court can decide to take it. And in this decision, they can say, well, we're done. The DC Court of Appeals did a great job. Or they can do like what they did in immunity, and they will say, yes, someone is above the law. Oh my gosh. So it is potential that they could do that. That's what the Supreme Court overruled, was the DC Court of Appeals. That's what they reversed. So, but they could decide, nope, DC Court of Appeals got it right, and we're not going to deal with it. So it is absolutely possible. Oh, thanks for coming by, Deborah. Thanks for your hard work. I appreciate it. I really appreciate it. Yeah, it is. It is a bit scary. I would agree. It is a little bit scary. Here, it's I've not seen a case where where the Supreme Court has been micromanaging it. I would say this is a micromanaged case by John Roberts. Now, whether that's okay or not, that's a different topic for a different day. But this whole issue on presidential immunity is being micromanaged down to the sentence. And, it really is. It really is. So I think it'll be interesting to see how the Blessing Game case, which is a civil case, plays out, not criminal. We'll see how that plays out on immunity and whether or not the Supreme Court touches that one, because Mr. Trump didn't even appeal the Blessing Game decision up to the Supreme Court. He let that one lie. And so he may appeal it later. So they may even come in and put some parameters in when it comes to civil presidential immunity situations. I really don't know. I mean, this whole issue is just really being micromanaged quite a bit by the Supreme Court. Well, by John Roberts. Let's be clear about that, all right? There's 9 people in the Supreme Court. It's not the entire Supreme Court here that's doing this. So, yeah, they have to hear evidence for right. And that's the thing, is that the evidence here is being heard by Judge Chutkan in order to make a pretrial ruling. She has to, because that's how the Supreme Court said she had to do it. But the Supreme Court's not hearing evidence. The Supreme Court will just hear whatever's been filed. So that's why Jack wanted to make sure his brief was exceptional, because this is what the Supreme Court's going to read after this gets appealed. You need to add some more Supreme Court justices. I would agree with that. Absolutely. I think 9 is not enough. I think it was enough back in, 1869 was the last time they changed the size of the court. It was enough back then, but, some things have changed since 1869. I would say it's okay. We could make the court a bit bigger. I wouldn't be against that. Had not voted that they will reverse their decision. I'm not sure about that. Was the meeting January 6th mentioned? Yes. So January 6th is going to be mentioned in throughout all of it. So they've kind of touched on it a little bit. Right now, we're just going through each state. The bulk of the January 6th information is actually going to be coming later. So we didn't go through it. We didn't go through that quite as well. Quite yet. Yep. But there's a lot of information in here, again, that he's adding that we didn't have before. It's not like huge, shocking information, but it's definitely filling in the gaps. Like, we had that first initial indictment, then we had the superseding indictment. We've got bits and pieces that we can pull from Giuliani's hearings, from Mark Meadows. Honestly, I tell you, these disbarment hearings, because of the way that they are done, the evidence that's coming in is absolutely fascinating. So you can see a lot of the evidence coming in from those hearings, but we've also got, we had a full week long mini trial in the Colorado case that came in. So we've got information kind of coming in from all over the place. So we're kind of piecing it all together. So this, I think, is another piece. Why doesn't this rise to treason? Treason's very specific in how it's defined in the code. And in my opinion, for Jack, he took a look and said, what's the absolute best thing? What's the best thing we can charge him with the most highly likelihood of accountability? And he picked these four counts. So we had a little bit of a hiccup with this 1512 with the case that came out from the Supreme Court over the last session. We had a bit of a hiccup here when it comes to other Jan 6ers, but not for Mr. Trump because the paperwork was involved. But these are the sections of the code that he felt were the most applicable. So, you know, if you want to go wrestling around with treason, I think if he thought he had a solid case, he could have. But I think the intent level for treason would have been, is the killer there. So you have to show that intent against the United States. And what he's arguing here is, I was president, I was trying to do the best thing I could for the country, blah, blah, blah. So that intent level, I think, would have really been the kicker for trying to plead treason out. See the charges when they seem simplified, you know, when you just boil them down to, you know, what the statute says. But you know, I mean, they're tough. This is a tough case, everyone. You know, this is a tough case because, again, you have to have that intent. You have the act, you have the intent, that equals your crime. So we've got to have everything set out here. What makes it easier is we do have one defendant here, but what makes it difficult is that we've got 6 co-conspirators unindicted, and we've got tons of other people involved. So we've got all of our special grand juries that have come in, so we've had all that testimony too, and this is an enormous case. This is definitely a huge, huge case. It was treason. Well, there you go. I mean, it's all right. You can say, it's okay to be like, I think this should be charged better. But, you know, I guess as an attorney, I kind of look at it like, you know, who are you going to put in? Who are you going to pull off from your bench? Like, oh, you know, I could have pulled this person in. I could have pulled that person in. It's the same thing. It's like, well, we could have done this. We could have done that. But, you know, you kind of got to go with what you've got, what you think is going to make the best play at the time. And so I think he did. I think he did a pretty good job. I think with these particular charges, if you read the history and the statutory language, you know, I think it's solid. But again, 50-50 shot in front of a jury, no matter what, everyone, 50-50, and I will stand by that. So anyway, with that, everyone, I know there's quite a few of you here, and I'm so thankful for you coming and hanging out, but I'm going to have to let you all go for tonight. I'll be back again, 7 o'clock Central. We'll pick up where we left off. We'll try to, you know, knock out another 30, 40 pages. We'll see how it goes tomorrow. But I thank you all for coming and hanging out with me. I really appreciate it and your interest. Again, you can pull this document up yourself online if you're interested in that. But I will be back again tomorrow to head over and try to do the next batch of pages. So have a wonderful night, everybody. Thank you all for your support and your time. I really appreciate it. So take care, and we will see you again tomorrow.